Thank you very much for coming to the webinar tonight. We really appreciate all of you taking time from your schedules to come here. And as housing providers, you're very important to our communities, and we really appreciate all that you do. We also want to let you know before we start that we're going to be posting a few short electronic polls so that we can get a better idea of the topics that you are most interested in and perhaps tailor this talk a little bit more toward those areas. And we will do that once I'm done with the introductions. We also want to remind you that at the end of the seminar, when you log off, there's going to be a link to a survey feedback form. And that form is very important for our funders and for Project Sentinel to improve. So we will ask you to please do that, even though it may be late and you might be hungry tonight after this webinar. Thank you so much for thinking of questions as well. And we will not use the chat function during this webinar. We're going to ask you to type questions into the Q&A function at the bottom or top of your screen, wherever it appears. And we will attempt to answer your questions tonight. However, if for some reason we can't, we will follow up with you. We're very interested in hearing your questions and trying to address them. Due to time constraints, however, we will try to stay on task and on time. So we'll go ahead and start with our agenda that you can see on the screen. Okay, after we get through the introduction, we'll touch on the existing rules and policies that were in place before COVID, the apartment rent ordinance and the tenant protection ordinance in San Jose, and AB 1482 that was effective January 1st, 2020, right before COVID really hit. Then we'll move on to the statewide temporary eviction protections, or what some people call COVID protections. Then we will also give you information regarding the new rent relief programs as best as we can. Some of them are still in process of being established. And at the very end, we hope to give you some information, if time permits, on small landlord mortgage relief. And just so you know, the entire slide deck presentation will be emailed out to all participants so that you can refer to it and you don't have to try to take notes during this presentation. So thank you very much. We'll go on to the first topic. So next slide, please. So one of the things that we want to bring to your attention is that the city of San Jose has a marvelous set of pages on their website with lots of information. And today we can only do an overview. So we encourage you to go to the city's housing website and search out more information to answer your questions or get a better idea of things that we touch on today. Thank you. So the Apartment Rent Ordinance, or ARO, has been in effect since September 7th, 1979. And so most of you are probably familiar with it and understand whether your units are covered by it. But we will go over some very general provisions of the ARO. San Jose also passed a tenant protection ordinance in 2017. And that ordinance, as we'll talk about, covers even more units in San Jose than the ARO does. Okay. The TPO is essentially eviction protections or just cause for eviction. Okay, we'll move on. Okay. So the ARO applies to a whole number of units that were built before 1979, if they have multiple units in a building, guest houses, and some other things that are pretty obvious under that ordinance. It does not apply as a general rule to single family homes and condominiums. If you have any question about whether your units are covered by the apartment rent ordinance in San Jose, please check online. There's a wonderful interactive map where you can put in your unit addresses and they will come up and tell you if they're covered by the ARO. If they are, there's registration requirements. I'm not going to go into the details, but those are things that you must comply with in order to be a housing provider that's covered by the ARO. The main feature of rent control or rent stabilization under the ARO was a 5% rent increase cap per year. That's a flat 5%. There were exceptions, and those have to be brought to the city's petition process, housing department, and then you can make an argument for why you should have a greater increase in a year, but they're very limited. Next slide, please. Okay, one of the newer protections for tenants is that San Jose and the state prohibit discrimination based on the source of a tenant's income to pay rent. So please keep this in mind and do not advertise that you won't accept vouchers or question somebody's ability to make rent or make a different rent for someone who has one particular source of income versus another. Those are all not permitted now. San Jose passed a rent increase moratorium at the beginning of the pandemic last year, between April 2020 and December 31st, 2020. The city really wanted to help tenants stay housed and not face increases. So there was no declaration required for the tenants, but there was a moratorium on rent increases through the end of the year. When it expired, there was a new rent increase moratorium passed, but it didn't actually pick up right after the other one expired. So there is a window between January 1st, 2021 and February 2nd, 2021 that has special rules. But at this point, any rent increase that's subject to the new moratorium requires the tenants to submit a declaration of COVID-19 related financial distress, and it applies to apartment buildings under the ARO and rent controlled mobile homes in San Jose. Thank you. Okay, so there are some benefits to landlords under the rent increase moratorium ordinance that is still in effect. We can go through them, but I will probably leave you to read them. I think one of the ones I'd like to highlight is number 4, where tenants are prohibited from making service reduction claims for closure of recreational common areas at ARO properties during this period. In several jurisdictions, we have seen tenants who bring these types of claims for the pool being closed or the fitness room being closed. Right now, under the San Jose rules, that would not happen. Okay. The Tenant Protection Ordinance, or TPO, that was passed in 2017 imposed what most people call a just cause requirement for eviction. A just cause means that it's an applicable, legal, appropriate reason for eviction as listed by the legislative body. So under just cause, there is an enumerated list. Some of them are at fault causes, meaning that the tenant's conduct is the basis for the eviction. However, there is a shorter list of what's called no fault causes, which allows a landlord to request or actually evict a tenant for certain things that were not the tenant's fault, but still require the tenant to move. And those are very limited, and you must comply very carefully. The TPO did cover more units than the original ARO. One of the big takeaways here is that some newer units were allowed to be covered by the TPO if they were up to 50, I guess if they're newer than 15 years old, they're not covered, but there's this period between 1979 and 2005. Those buildings are covered by the TPO. Also unpermitted units. Okay, so there is a larger net for the TPO just cause eviction than there was for the rent control. Okay, and again, there are exceptions to most of these rules and policies. So the TPO, although it was expansive, still exempted duplexes and single family homes with ADUs, are accessory dwelling units or granny units. And of course, government subsidized rental units as well, and hotels. So I don't want to go through every single part of this list because we are trying to keep on time, and you will get a copy of them. But please become very familiar with the causes that are permitted for eviction. So we're going to go through the next few slides rather quickly, Clay. Okay, here are the no fault causes under the San Jose TPO. You can see the types of things where it's not the tenant's fault, but for some other reason, they are being asked to move. Okay. The important takeaways from a just cause ordinance is that you have to actually fall within one of the reasons that's enumerated and then state that reason in a written notice of termination. Okay, there's requirements for notice. And also in San Jose, the landlord must file a copy of that notice of termination with the city of San Jose within 3 days of serving the tenant, so the city can monitor what's going on. I'm not going to dwell on this, but there are penalties for non-compliance. A lot of these criminal and civil penalties for housing providers have come about because so many people didn't comply in the past. In San Jose, the TPO does allow you to negotiate a buyout of a tenant to get them to move out voluntarily, but there are a lot of requirements, and we just want to highlight that they have the right to refuse an offer, and also they can rescind an agreement up to 45 days after they've signed off. So it is something that you have to plan and negotiate and then follow up on. All of the policies related to tenant protections include some sort of anti-retaliation language. So that means that even though you would like that tenant out and there's a lot of hoops to jump through, you have to make sure you are not taking it out on the tenant. And also that the tenant, if they're asserting their own rights under these protections, that they cannot be subject to some kind of harassment or retaliation.
Sandra, I'm just going to pause for a second because I realized we didn't launch our poll at the beginning.
Right.
So we are going to launch a quick poll because we have a lot of topics we could cover with a limited amount of time, and we want to kind of know what are the most important topics for the almost 100 people that are in this webinar at the moment. So Christina, who's behind the scenes, if you could launch that poll. So which topic is most important or that you have questions about today? Just wait a couple more minutes. We can kind of see it ticking up. It's looking like rent relief and small landlord mortgage relief are in the front. 69. Thank you for taking the time to do this. This helps us a lot and will hopefully be beneficial to you. Clearly, rent relief is the big winner here. And coming in second is small landlord mortgage relief, and third is the just cause protection at 6 people, but there's 50 people interested in rent relief. I will remind everyone that while this workshop is open to everyone, we are focusing on landlords. That was the purpose of this workshop, to give landlord perspective. So we're not going to go into too much detail about the tenant perspective of rent relief programs. There will be future programming about that. You can stay and learn some important information, but I just I want everyone to be aware of that. So I think we're done. We can close out the polling and I'll let you continue, Sandra.
Thank you, Emily. I do realize that some of this information about the ARO and the TPO and even 1482 may be repetitive for some people, but I think it's worth going through, but we will do it in a quick fashion. So we are now talking about AB 1482, the California Tenant Protection Act of 2019, which went into effect January 1st, 2020, and was meant to be in effect for 10 years. However, we are just before COVID, but let's start looking at what the legislature had put into law throughout the state. First, there was rent caps, and then there was just cause. The rent cap under AB 1482 is 5% plus the cost of inflation, so it is higher than the San Jose ARO. So if you have a property that's covered by the ARO, you will actually be limited to 5%, period, because the most protection in either act is what's going to rule. So the tenant gets the benefit when you compare them. Okay, but if your property is not subject to the ARO, then AB 1482 might apply if you meet other criteria. So limited rent increases to 2 per year per 12-month period, and cannot exceed the total of 5% plus cost of inflation. There are some exceptions which are listed, which I think are self-explanatory. Okay. The just cause protections of 1482, as I said, applied statewide because there are a lot of places that didn't have anything. San Jose happened to have an ordinance already. We've been over the fact that the TPO may be more protective. All right, we've mentioned that, but 1482 may apply. But it does require that all tenants in the unit have lived there for a continuous 12 months, or at least one tenant has lived there for the continuous period of 24 months in order to kick in. Okay. And there are various exceptions, again, to the rent caps of 1482. We can have you go over those yourself. And there are also exemptions from just cause in 1482. I'm going to highlight one or two that I think are really important, but please look at all of them when you go back. If you have a single family home or condominium that is owned by a non-corporate owner, you must give notice to the tenants that they may or may not be covered. You're supposed to communicate with them. If you do nothing, the assumption is that it is covered by just cause, and so you're subject to those requirements. The other point of kind of reference is duplexes. Duplexes are treated differently in several of these policies and laws. So under 1482, if the owner of the duplex resides in one side and a tenant resides in the other, it is exempt from just cause. Okay. I'll leave the rest. Okay. Again, 1482 lists your causes that are at fault and not at fault. I'm going to let you go through those, but we have a slide that compares the TPO and 1482, which may be helpful. We'll keep going. So here's a table that compares the two. So under at fault, you can see that most of them overlap, although there are a few that don't at the bottom. And under no fault causes, again, most of them overlap, but one. So you have to be very aware of what you're looking at in terms of the law that applies to your units. And just as a note about no fault causes for just cause usually require a landlord to offer relocation assistance. And that differs between the San Jose TPO, which is very generous, and AB 1482, which is less generous. So the tenant always gets the benefit of the more protection or more generous legislation. Okay, there we go. So we are at a point where we want to break and take a moment to take some questions if we can, because we've covered everything that we wanted to cover that leads you to the point of the COVID emergency measures. So let's see if you have questions about what came before that.
So there's one question that we have that I think you just touched upon in the last slide, but I'll ask it out loud. So the question is, when state, county, city law are not the same regarding the same issue, which one has the highest authority?
Okay. And one thing I need to do is give you a caveat that I didn't do in the beginning, which is that we cannot give legal advice. You should seek your own legal advice. But the general rule, as we give an overview, is that the most protective policy is going to help and rule for the tenant. So if the tenant gets more protection under state law, use state law. If the tenant gets more protection under the local law, use the local law.
And I think there's a couple questions here that we're gonna refer you to the landlord hotline because there's very specific questions. So we'll type that in a second, and the other ones will relate to a later section. Oops, we have one more. Okay, another question about, we will get to, was there relocation assistance slides? I thought there were.
Well, it was in the chart, at the bottom of the chart.
Oh, it was in the chart.
We can go backward or we can talk about it.
Well, I mean, it's going to tell the person's question about how much is relocation costs if I need to evict, if you have a lawful reason, depending on whether you're falling under AB 1482 or the TPO. Going back a few slides, we have links to the City of San Jose's website under 1482. If that's the applicable law, it's equal to 1 month's rent, and it needs to be offered within 15 days of serving the termination notice, or the landlord may waive the last month's rent in writing.
Thank you.
And very quickly, because I just said about the rent relief, we will get there. Okay. I think we'll move on in the interest of time, and we'll try to answer your questions by typing the answer or referring you to the landlord hotline otherwise.
Okay, thank you very much. Those are all good questions. So now we're going to look at the eviction protections that were enacted basically in response to the COVID pandemic and the rash of people who lost their jobs or whose income was reduced, and so they couldn't pay rent. So one of the things to look at is AB 3088, which went into effect August 30th, 2020. And it replaced the City of San Jose and Santa Clara County eviction moratoria. So now we're looking at a statewide protection. It was extended and expanded by SB 91 because AB 3088 was about to expire on January 31st, 2021. So then it was extended and then certain things expanded to June 30th, 2021. Okay. The purpose of all of these COVID protections was to keep people housed and avoid massive homelessness. That's the last thing we need in a pandemic. And also to protect the public from COVID-19 spreading as people were moving about if they have to move. We wanted to keep them home according to all the health orders. Okay. So there are a couple of periods to look at in terms of the COVID year or year and a half that we've had. The unpaid rent between March 4th, 2020 and June 30th, 2021 is the target of these protections, okay? It's based on COVID-19 financial hardship, and if the tenants do what they're supposed to do to get protection, they may not be evicted for non-payment of rent during that period of March through June, okay? During the first part of this period, March 4th, 2020, through August 31st of 2020, They didn't have to make payments, but they did need to do a declaration of COVID-19 related financial distress. Okay? So what they did is they told you that they couldn't make rent, and you had that piece of paper, but you didn't have funds coming in possibly, or you had only partial funds. What happened when everything got reevaluated by the legislature is they said, well, unpaid rent from September 1 of 2020 through June 30th, 2021 should be paid at least at the level of 25% of the total rent due for that period. So they still have to do a declaration regarding the hardship, and they also have to pay at least 25% of the rent due for that period by the end of the period. And that is the interpretation we have seen so far, is that the 25% of that entire amount of rent is due by the last day, June 30th, 2021. The declaration form that the tenants are supposed to use is available online and many other places, but frankly, it is the duty of the landlords to provide a blank, and that's what we put up here. If you give a notice to pay or quit, and it must be a 15-day notice under these emergency rules, it has to meet certain requirements, and it also has to attach a blank declaration of financial hardship or financial distress for the tenant to fill out and return to you within 15 days. Okay. So one of the things that happened with the extension of all these protections was that it was extended to almost all residential tenants, including mobile homes, and it doesn't matter if they're legal or illegal or whether they have a written lease or not. Basically, all residents that are tenants are protected. One thing to note, though, is that none of the unpaid rent is forgiven or waived by these bits of legislation, okay? They're still responsible for that. And then until June of 2021, until the end of June, I should say, of 2021, just cause eviction protections were extended also to almost all resident tenancies, sorry. So what happened is there's a lot of protection for tenants to try to help them get through this. And we will get to some things that are available for landlords as well. Okay. So here are a few things to note. The tenants still have to meet certain requirements and take certain action in order to be protected by these laws. The landlords must serve certain documents and comply with the laws in order to reserve their rights to collect these rents or to evict these tenants. And the rent is still owed, even if it's not subject to an eviction, because the tenants have done their part to avoid that. They're still subject to collection in small claims court, but only after August 1st of 2021. Okay, if for some reason the tenant receives rent relief funds and tenders them and you refuse them, as a landlord, you can be barred from recovering certain monies from the tenant in court. So there are some repercussions in how you handle rent relief funds, but we'll probably touch on that later. Okay. There are certain other protections that are listed here that I think are really important, but I'm not going to go through them one by one. Please just be aware that you can't retaliate or treat a tenant differently because they owe rent for that protected period if they have done everything they were supposed to do.
Okay. I am going to quickly pause. There is one question that I think I will answer. Just go ahead. Oh, where did that go? There is somebody who said they, well, they were evicted mid-COVID, in July 2020, and their deposit was withheld for past due rent. I want to just clarify in the last slide that the deposits can't be used towards back rent for tenants that are still living there, but when they do move out, it can be applied towards that. I suggest this individual also contact, because it sounds like they're a tenant, they can go to the city website or contact BALA, Bay Area Legal Aid, their tenant hotline, to see if they have any rights regarding that issue. And the contact info is at the end of this presentation, but which you will receive if you registered by email. And then there was one question I thought I'll let you address if you'd like, Sandra. If a tenant is month to month, has been living in the property for 6 months, but has not paid rent for 2 months, they sent a notice. They thought that they could terminate the contract at any time, but we just covered those temporary eviction protections. This person said they sent a notice 14 days to pay or quit. It should be 15. Once it expires and the tenant does not leave, what should they do?
So is this a landlord asking that question?
I believe so.
Okay. So once you give the notice, the 15-day notice, and it lists a reason why, the allowed reason why you're asking to terminate the tenancy, and they don't move, then you could arguably start a UD proceeding, an unlawful detainer that people usually call an eviction. But you are going to run into some resistance probably if the person has a COVID financial hardship, because they may be protected. So one of the things that we will tell you is that a tenant may fill out and give you a declaration regarding hardship late, even if they didn't do it in the 15 days right after you gave them the form. So there are some protections still in place, but you would go through your usual channels to see if your court will hear an eviction.
And one more question that does relate to this last section, and forgive us, we edited a lot out of this presentation because there's a lot to cover. What's the limit that can be recovered in small claims court? What if they owe more than the limit?
Okay, so one of the things that happened was the small claims court $10,000 limit of relief has been extended and enlarged by this legislation that contemplates landlords going to small claims court to collect against people for back rent. So the jurisdictional limit has been increased for that purpose. And the courts are going to be ready to hear these cases after August 1st.
Thank you, Sandra. I'm gonna go into the rent relief program. So
Do we need to send the other poll?
Oh, right.
Okay.
So we're gonna launch another poll. This one is, so we just want to get a sense of how many of you out there have tenants with unpaid rent. And our next question will go to how much unpaid rent there is. And a number of the questions in the Q&A do have to deal with rent relief, and I will try to cover them as best I can, but I may not hit your specific question, but we will touch upon those subjects. And if we don't address it, we'll make sure to direct you to the right resource. So looks like 30 people will share the results, so we get an idea. So it looks like there's a lot that are 1 to 3 tenants or even more than 10. Thank you all for sharing that. That's helpful for us too. We can share this this information. It's anecdotal, but it's helpful to the city to know as well. Okay. And then do you want to launch the other poll?
I think we should. There we go. And I want to thank everybody for sharing. It really does help us get a feel for who our audience is and what kinds of topics are most helpful.
And since we didn't clarify this, let's say just in total of the tenants that you who do have unpaid rent, in total, how much is, oh, I don't think we clarified. So quite a few of you have over $10,000 in unpaid rent. That's a significant sum. Thank you very much. That's very helpful for us and gets an idea of what we should focus on even more. Okay. Did the short results get shared? I'll just share them one more time just in case. Okay, moving forward. Let's go there. So the COVID rent relief programs, you may hear in the County of Santa Clara about 2 different programs. We're trying our best to just steer people to us and to the website so they don't have to be concerned about what is what. But this all relates to money that came down through the federal government and that the state set some parameters around in SB 91. So who qualifies and what is covered? Eligible tenants are impacted tenants households with at or less than 80% of the area median income. Now this is an household incomes are a measure made by the federal government by county. And in Santa Clara County, 80% of the area median income is 112 for a family of 4 is $112,000, 150, and 50% of the area median income for Santa Clara County household of 4 is 78,950. So these numbers change a little bit depending on how many members are in the household and what income bracket you're looking at. We have some useful charts on our COVID-19 website. So I will say this website often and hope you go visit it because it will be updated continuously. We're at housing.org/COVID-19. There you will find a button with an AMI calculator and you can see a nice little chart to see where your tenant may fall. So the priority of this funding is that for the first few weeks of it, it's going to assist households with less than 50% area median income, and then households who've been unemployed for 90 days or more before applying. Then they will start processing the applications for those under 80%. The priority is for rent arrears, but a tenant can also apply for prospective rent 25% if they know that they're going to have trouble paying the future rent through this moratorium period. Then if subject to funding availability, tenants can also apply to cover utility payment arrearages and other housing expenses. I think I do that. So like I said, there's 2 programs that are available in Santa Clara County. The one that the landlords can apply on behalf of their tenants is through the state of California. This program can be accessed by both landlords and low-income residents, and part of SB 91 provides that landlords may apply to, and if they agree to this, they will receive 80% of the rental arrearage between April 1st of last year and March 30th of this year, if they forgive to the remaining unpaid rent for the covered period. The tenants will have to complete their portion of the application, but especially for smaller landlords or maybe less experienced landlords, you should know that getting a check for 80% of a debt that's guaranteed that you will get that money, there's a lot of benefits to that, because if your tenant's not able to pay rent, it's likely that they're going to be hard to collect any money from. So while we talked about how you can go to small claims court and get a judgment for the back rent, you can consult any attorney to find out how difficult collecting that judgment may be. So that's just step one. It's not an instant check. So we counsel landlords to consider this, give this a lot of consideration and weigh the intangible costs of waiting and going to court and all that against what advantages there are to doing this. So if a landlord chooses not to participate in that option, the tenant, and this check goes directly to the landlord. I want to specify that. So when you initiate the application, you will provide how you want it paid and everything. And once it's complete and approved, that payment, will end up in direct deposit or a check mailed to you. If a landlord doesn't want to participate and the tenant is eligible, the qualifying tenant will get the value, they'll get rent relief valued at 25% of the unpaid rent. And I believe it goes to the tenant. So subject, like I said before, subject to funding availability, tenants can, once they've received coverage for the back rent, they can apply for 25% of forward rent. And I believe there was a question about the Section 8 voucher. And so voucher participants like Section 8 can obtain relief, but only for the tenant's portion of the rent under the lease, because with the Section 8 voucher, you're receiving a chunk of the rent from the federal government, and then the tenant pays their share of it. So the other program that some people had mentioned in the chat is a coordinated effort between the city of San Jose and Santa Clara County, because they are both a county and a city with over 200,000 residents. They got some additional funding from the federal government, and they had an option to administer that portion on their own. So they approved this week a plan that it will be a hybrid program that is paired with their homelessness prevention system program. And their aim is to target households that are less than 30% of AMI. So the extremely low income and most vulnerable residents, people who may not have traditional leases. So we don't have the website yet because the approval just happened. There has to be a memorandum of understanding that has been put forth between the state and county and city, but the contract still has to be finalized, and they're expected to launch in the next month. Now, this relates to the state program. While the state program is definitely accepting applications for rent relief from Santa Clara County landlords and tenants, they are holding them, and nothing is going to be processed, start process where they review to make sure it's okay until the county and city program launches. So if you've completed your application and the tenant has to, and you're waiting, and you're wondering when the check may come, we're going to have to wait until both those programs are live. So this is not this is a place that landlords can direct their tenants to, and we absolutely encourage landlords to share this information when we have it. We have links later on about where to find this, and I expect that in the coming weeks we will be partnering with the county and the city and other jurisdictions to provide very specific rent relief seminars. But I wanted to give people an overall view of what's out there, and also hear your questions, because that will help us educate the public. So where do you apply? So landlords can apply on behalf of their tenants using the state's program portal. You visit so you can visit our website, housing.org/COVID-19, and we have links to the tenant application and the landlord application. We also have checklists that are published. I included some of that information in this presentation, but I encourage you to go to our website, because we're getting materials from the state that we as a local partner are disseminating and explaining to landlords and tenants alike. And we also are trying to gather as much resource and easily accessible info to put on our page. So I strongly recommend you bookmark that page to learn about other programs in the future. You also, the place you will go to apply is the housingiskey.com website. I've also put the other link that works the same way. That will take you to the state's rental housing portal and homeowners. So they, the state keeps updating this with all sorts of useful information and flyers and things in multiple languages. You can even select your language up the top here if you want to hear it or read the information in your native tongue. This is where you will, where I've highlighted in yellow, where you will start the application process. So the first few questions of the application process will determine if you as a landlord are eligible. It's going to ask you what county, it's going to ask you if you fall, if your property is in some of the counties or tribal areas listed, you say no. Then it's going to ask you if you have tenants, one or more tenants with unpaid rent, you can say yes. And then it's going to ask you if you are willing to accept 80% of the arrearage and forgive the remaining 20%. And from that point, it will take you to the landlord application where you will register, log in, and start that process. So eligible landlords are ones with one or more tenants that are below, where their household income is below 80% of the AMI and have unpaid rent between April 1st, 2020 and March 31st, 2021. The requirements of this program: all payments must be used to satisfy the renter's unpaid rent for the period between April 1st of last year and March 31st of this year. Renters will have to take steps to verify eligibility requirements and sign the application. The renter's household income must be at or below 80% AMI. And then what you can do to get ready to apply is that you'll have to verify your ownership. So they list some documents that you can provide to show that you indeed own the property. So it'll be a property deed, mortgage note, property tax statement. You'll also have to provide a tax ID number, and that's very standard for all rent relief programs. They may use any information given to, they may cross-check it to verify it, but there's no affirmative, they're not going to affirmatively, they have to see if you have accepted rent relief from other programs, so there's no duplication. They also will want to see a lease or rental agreement that shows the renter's name, that the renter lives there, and that also reflects the monthly rent due. You'll also be asked questions about showing what rent was paid, what was not paid, and that sort of thing. And this is the portal where you would go to register and sign in. I see a lot of questions coming up, so I'll try to speed up. I just want to give people an idea of what it looks like. Once this application process gets started for either side, we just wanted to note, because we heard this question and then we went to go test for ourselves, that so we heard of a tenant who received an email from that looked almost suspicious to them. And it actually came from this Neighborly software. That's the software program that the state is using to do the application portal. So, you know, these days people get phishing scams and all sorts of things. We wanted to show you a screenshot of what the email might look like that a tenant gets or a landlord gets after this application process gets started, so everybody knows. So this is what it is, and it says California COVID-19 rent relief, but everywhere it directs you is going to be back to that portal. Just to give a process flow, because I'm sure the questions might cover some of this. So I mentioned slightly before that we were a local partner. We were part of the local partner network with the state of California. So we are getting a lot of information and attending weekly meetings to find out changes or status of the state rents relief programs. So I encourage you to go to our website, because as we learn more information, we're going to share it with you all. And these process charts are an example of some of the information that we're given and in order to help educate people. So the landlord would first confirm their address, they create an account, they would collect the tenant information. And if you have more than 10 tenants with an arrearage, there's a way to do sort of a bulk filing. Collect the information on the rent owed, collect your bank account information showing what's paid, has been paid or not paid, and the verification documents, and then agree to the program terms. And at that point, the landlord's portion of the application is complete and the landlord would sign. At that point, the tenant receives a notification that the application's been submitted. It checks if they'll have to create an account, they'll have to collect certain information and any missing information. So if the landlord has already uploaded the lease agreement, the tenant won't have to duplicate that information. They will just verify. So for some, it's, tenants, we are asking if they can go to their landlord first to see if the landlord can help them with gathering this documentation. So once the tenant does all this and then they sign, the application's complete and it goes for review by the state's implementer. So there's a case management system there and they will communicate with the parties by email. Before I go into small landlord relief options, I see that there are 31 questions. So landlords who have tenants that are not cooperating, we strongly encourage you to use our service so we can connect them to other places where we are happy to educate tenants on the program and find out what their concerns are. So we are really urging tenants and landlords to work together. So if you have a tenant that's uncooperative, you should look into your dispute resolution, your local dispute resolution provider. We're all working together to get everyone educated so we can be prepared to reach out to a landlord or a tenant where their respective landlord or tenant has said, can you help me work with them? So that's what I would say to this person who's asking that question. Sandra, did you go through any of the questions? Do you want to?
I did, and a lot of them have to do with uncooperative tenants. So you've answered that, I think, just now. And then there's some technical questions about the programs themselves. I'm not sure that we have more information at this point, but you can look at that. A lot of questions about uploading documents. So let me just give you a question. The application didn't have a space to upload the property tax statement or deed, but it did have a space for a W-9. So the question is, would the landlord get a chance to upload additional documents later? So that's just typical of some of these questions.
Okay, I believe so, and that makes me think we need to set up an email. You can, for now, if you put landlord rent relief application in the subject heading, we will make sure we get someone who can forward your question on to the right people. If you email us at info@housing.org, but please put landlord rent relief application question in the subject and we'll know to direct it to the right person. And then tell us what issue you were having and we'll try to get the right information, answer your question, or let the implementers know what's going on and alternatives that might need to be provided. So I've used this metaphor a lot the last couple of weeks, but this is an enormous undertaking that has never been done in history. The state is trying to disperse $1.6 billion in rent relief in a short period of time to millions of people, landlords and tenants alike. So they're trying to build lightning fast speed, a portal that can handle all of this, prevent fraud and fulfill the government's requirements. And it's almost like building the plane as you fly it. So any questions or any problems that you come, that's what our job as a local partner is supposed to do, is to deliver these so they can be addressed. So encourage you to let us know those specific technical problems so we can get that to the right people.
I have a couple more questions that I think you might be able to answer. would the rent relief apply for a tenant who has moved out? In other words, you're owed back rent and the tenant is no longer on the property.
This is a question we get quite frequently. Through the state program, no, unfortunately. However, many state legislators have made lots of promises and declarations that they are looking at other ways to deal with this to help those small landlords who this disproportionately impacts on the landlord side. So please, leave that question open, because hopefully there'll be future legislation. If your tenants fall within the city county priorities and homeless prevention network, there may be a way for them to qualify for those expenses as housing related. So that's something that might be permissible, but it's going to be a lower priority. But this is something that all of us across the spectrum are aware of for both landlords and tenants. So just stay tuned, and hopefully there will be more to come to address this.
Okay. Another quick question, I think, is can you apply if your tenant income is over the 80% AMI?
If they are not eligible, so that it's based on 2020 income, but that the rent relief program is not available for in that instance.
Okay, and I'll take another one or two. You can decide on timing if you can
Okay.
answer these now or we need to address them later.
No,
There was a question about what happens if you're filling out an application that asks for the tenant's email address and they don't have one.
that is an excellent question that I myself have tried to bring up. We are trying to see if there is any possible way to have tenants use a cell phone number, because most people have cell phone numbers. Right now, one option you could consider is working with the tenant and seeing if they have a trusted person with an email address, whose email address you can use. It's not perfect, but that's just one idea I have. But I think open lines of communication are the best thing, I'd be interested to know if that precludes you from going forward in the application, or what other, what it says when that happens. So I tried to make my own dummy account to see what people are experiencing, but if you could send us an email that tells me what it says when you try to do that, that would help us notify the state and other agencies working on this to try to work on a solution.
Okay. A lot of the other questions have to do with things you've already covered.
Okay.
I would suggest that we go on, and if there's still questions out there that haven't been answered, they'll be answered after the program.
Okay, that works. Now, Sandra, do you want to go over the small landlord relief?
Okay. So there are a few things that are out there for small landlords who are facing problems making their own mortgage payments because they're not receiving rents. Essentially, they're affected by COVID because the tenants were affected by COVID. Or perhaps they have their own jobs and those jobs got cut or reduced. So the definition of a small landlord is an owner of 4 or fewer properties, and each property has no more than 4 rental units. Okay, so you do not have to have any of them be owner occupied, but there has to be at least one tenant who has not paid full rent during the period that we're talking about for COVID, from April of last year, basically through this year. Okay. So one of the options is to go to your lender who holds your mortgage or mortgages and ask for a temporary suspension or reduction of the mortgage payment for a specific number of months. That's called a forbearance. And a lot of the, under the CARES Act that was passed last year, a lot of the government-backed mortgages are required to look at this request very favorably, okay? You could get up to a year. Sometimes it was mentioned that it was 6 months and then could be renewed for 6 months. But the government-backed mortgage holders were told, please grant these at all, if at all possible. Now, if you have a private lender that's not government-backed, then you're just negotiating with them like you would for any other kind of relief, but they were also encouraged to grant forbearances. The mortgage modification option is a permanent change, not a temporary one. And some lenders will also do a mortgage modification for you because they want to see you continue to make the mortgage payments. So they'll change the interest rate, or they'll change the payment amount, or they'll extend the term, something along those lines for the rest of the loan. And also sometimes they'll negotiate a repayment plan where you're making your current payments starting a certain date, but you also pay the past due payments through smaller increments over time. So those are all options that mortgage holders can look at to help out. Okay. So Emily, I think this is something that's so new that I think we're just going to introduce it with the slides.
Okay.
Okay, so there is an American Rescue Act that is being considered right now. And we don't really know that much about it. I have to tell you, it's so new. But these are the slides that one of our housing counselors has put together to help out. And I'm going to let you all read those slides on your own because I don't have anything to add to them at this time. Okay. And you will get a copy of all of this in an email.
Okay, but we still have half an hour, so that's probably a better use of our time. Oh, I am not muted. I've tried to go through and mark the ones. Okay, I'm going to answer one question out loud if that's okay, Sandra.
Yeah, go ahead.
It's still about the rent relief. We'll come back to the mortgage relief question, and we're going to launch a poll in a little bit about what future webinars you would like to have. I think that's the poll, or it will be in the survey. So if there is more detailed mortgage relief information you would like, we will be scheduling webinars on that specific subject very soon in the future. So someone asked, my rental property is in San Jose. Do I have a choice to apply either the state or the county city program? Which one is better? So this is where this gets very confusing. The landlords can only apply to the state program. Their tenants would have to go to the county and city program if they fall in that extremely low income category. However, when the tenant goes to the portal, if they, I didn't want to say that. So you're free to provide some information if you think your tenant will get, if they fall into this extremely low income category or risk of homelessness, there could qualify for 100% of the arrearage and even future rent, because the idea of the homelessness prevention program is to keep people housed and also ensure some housing stability for them. So it's really going to depend on your tenant. There's nothing to preclude you from beginning the application process through the state portal. And if the tenant ends up qualifying, the state portal is supposed to be designed to redirect them to the county city program if everything works perfectly.
There are a few questions that go back to the emergency COVID relief. So I'll take some of those but let's see if there are any more related to rent relief that you want to answer first.
Just go ahead and see because there's so many here.
Okay.
If you can answer some, that would be great.
All right. So one of the questions that we got is what happens if you have tenants who you know were still working full time or receiving regular income, but stopped paying rent due to the eviction moratorium? We've heard from a few landlords that felt that tenants were taking advantage of the situation. They still need to do a declaration regarding the COVID impact. So if they have not provided that, they're not going to have full protections under the eviction protection. So they would have to show some kind of impact. ultimately, if you took them to court. And let's see. There was a question also about if a tenant who moved out owed rent, could you, even though it was during the COVID period, could you collect the rent? If they've moved out, the eviction protection then doesn't have any real effect, but you can always collect or sue for the back rent in small claims if you can serve them. And that is a question that came up, is how do you find a tenant who has left and not given you forwarding information to find them? And that is something that unfortunately is just a regular issue or hurdle in suing people, is finding them and serving them with papers. So unfortunately, there is no magic wand on that.
There was one question about if you give a year notice to sell, do you still have to pay the relocation fees? That very much depends on what law the property falls under. So it depends on what where the property is, how many rental units are on the property, what year it was built, because you'll need to know whether you fall under the TPO or AB 1482. If you're just under the, if it's a single family home, I would definitely call our landlord hotline to find out if your specific situation might be covered by the statewide eviction protections. But if it's normally not covered by anything else, there's no relocation payment.
There have been a couple of requests to repeat the email where they can send questions. Could you do that for us?
Yes, it's info, INFO @housing.org.
Okay.
And is there a deadline for the tenant to file their part? This is, we're trying to get more clarification on. I think it's a little bit relaxed now because we're still rolling out, and for all the reasons that I've said, that they're not processing the Santa Clara County applications yet, and also the whole building the plane as you fly it. But if you're having trouble reaching your tenant, please contact us or some other provider, and we will try to help you reach out to your tenant if you fall under one of our jurisdictions. But we'll try our best to get you connected to help, or help you get connected with the tenant.
Right. So I think a lot of the questions that we could answer, we've answered. There are a few that just we don't know yet. And we're going to have to keep you informed, and you're welcome to ask the city and also Project Sentinel for answers as we go forward. We want to see if there's any additional questions. Please type them in. We have a little time before we're going offline here, so please feel free.
So I think a lot of these, where can I get the form for the ERAP form from Landlord? So go to housingiskey.com or go to our website. We link to it, and there's a way to download a PDF of the entire application so you can get an idea of what's asked. We also have the checklists on our website, so you can know to better prepare. And just going back to that website that I really want to encourage people to use, because we're trying to use that as the main vehicle of getting up-to-date information out.
So Emily, there are a couple questions I found that I don't know that we've addressed directly.
Go ahead.
One person asked about a group of 4 people who rent a single unit. 2 of them have been paying in full. 2 of them have been affected by COVID and paying partial payments. Is the landlord still entitled to get relief for this partial situation where partial rent is missing?
If they're not receiving, so the household is going to be all people who live in the lease. Live in the unit. So the landlord could apply if they're not receiving full rent. And it depends on what your contractual arrangement is. I know there are situations where sometimes landlords contract with each individual person. But you, the landlord, is this a subleasing question? It very much depends on the particulars of your situation. I would put that question into to either the landlord hotline or to the email address info@housing.org, because there's some things that we're still waiting for the state to clarify. And so there may not be a concrete answer just yet.
So a follow-up question, I think, from a different person is, if someone has no income at all, they lost their job, are they 0% AMI, or does somebody look back at the last prior tax return to determine their level?
That's an excellent question. So the state program, they're basically looking at 2020 income annual, so what's on their tax return, but there's lots of alternatives if they, if there's other circumstances, it may put them lower in the priority. This city county program is not so much concerned. They're concerned about the tenant situation right now. So it's not just about what they made in 2020. Have they been unemployed for a long period of time? Are they at risk of homelessness for other reasons? Also, people who have been unemployed for 90 days or more are in the priority queue. So that would get them ahead if they did not fall in the eligibility bracket for 2020.
Okay, I'm going to have a couple more for you, Emily, if you're up for it.
Yep.
We have some really intriguing questions here. So how about, is there a limitation on the local San Jose rent relief funds, or is it for tenants only, or can landlords apply for those? So
I think I said, so the only place where landlords can initiate the process is the state program. Tenants will have to initiate the process through the city county program.
Okay. And I would like to address a question about if a tenant goes ahead and pays the 25% that's required for that COVID period, and they've given a declaration regarding COVID financial hardship, will they ever have to show any proof of their COVID hardship? Emily, let me take a stab, and then I'd like to know if you agree. From my point of view, the landlord is not allowed to ask for backup information unless they already know that the tenant is more than 130% of AMI, and that's a whole nother question. Assuming they're not, the proof cannot be demanded of the tenant, but if you end up suing them in small claims court, I do believe that the judge would want to know if they truly have a hardship, because they signed a declaration under penalty of perjury. So there might be some question there of supporting the declaration. What do you think, Emily?
Sorry, I was reading some questions.
There you go.
So in the eligibility for showing hardship part of the tenant application, they will ask you if you have supplied the declaration of COVID-related financial distress that is signed under penalty of perjury. I think you probably just said all this. That we didn't cover in the statewide eviction protection part of this presentation, that if a landlord knows their tenant household is over 130% of AMI, which is quite high, so the only way a landlord would know is if they have the application records or some other pay stub. They have to have prior evidence. If that's the situation, they can demand documentation of the impact, like a termination letter or something like that. But the landlord has to have proof that the tenant household is in that range to insist upon it. And there's all sorts of pleading requirements that go into that later on if you do file a UD.
But if somebody is in small claims trying to collect and the tenant is not in that category, they're a tenant below that 130%, would the tenant have to provide any proof to back up the declaration? I think that's the question. You're saying no, and I'm saying maybe. Okay.
No, unless they're challenging the veracity. So it's sworn under penalty of perjury. So if the landlord wants to, challenge that in a court of law, if they believe somebody's perjured themselves, that's a process that can be taken.
Okay,
But I don't think small claims is going to deal with that.
so there is a question about if the landlord dropped the rent during COVID voluntarily,
Mhm.
does that become the basis of future rent increases? And I think the answer is no. You can voluntarily drop the rent, but then after the emergency is over, you can go back to where the rent was
This is for San Jose.
for San Jose. Yeah.
So
Okay.
correct, I'm just gonna say it again, landlords do not apply. They do not initiate the process or apply to the San Jose program.
Okay.
So
there are a few other questions, but a lot of them are similar to what we've talked about. So I just want to make sure if anybody has additional questions, that they put them up on the board, because we are going to do a closing in just a few minutes.
And one of the, well, I'll just answer out loud. One question is the rent relief dispersed by each city or Santa Clara County? That it's a coordinated effort. There's two programs. There's the state program, through you apply through the portal, landlords can initiate that. And the county city programs will be run by or handled by Destination Home and Sacred Heart, but they will be working with their local area networks, and it will be a concerted collaborative effort. But the checks, I think, are only going to come from one of two places.
There's still some good questions we'll try to answer. One of the questions is, how would tenants know that the local San Jose funds are available in the local rent relief? The word is really going out through all the housing groups and the nonprofits in the city, trying to reach as many people as possible. And there's another question I want to touch on, which is that a tenant doesn't want to apply for rent relief because of immigration status. They're afraid. Do you want to handle that one, Emily?
Yeah, so this is not a question on the application, and the state has repeatedly stated that they will not be notifying or checking immigration status. That is not part of the application process. I understand people still have fears anyway. I encourage you to have your tenants contact Sacred Heart, Destination Home, or their local community service agency to learn more that would help them feel more secure. But this is a concern we hear. And to piggyback off what Sandra said, our organization is also working with with county agencies, the city of San Jose, the emergency area network, which is all the community services agency. We are, as I speak, working on a plan to get wide distribution of information and reach vulnerable communities, both and be there for tenants and landlords to help everybody get the help they need and get access to these funds. So there will be things happening in the next month or so. Like I said, we're building the ship as we fly it, the plane.
So there's I'm addressing somebody who came late, but one of the new questions he had was, do you need to know the social security number of your tenant for the application?
I don't believe so. You just need to know their name and address and email. That we're working on that.
Okay.
Okay, let's see. And please, people and participants, if you can look at the Q&A, click on it, you might see answered questions. I've put info@housing.org. I strongly urge you, if you are going to write an email, put landlord rent relief application. That way it will get to the right people and we can effectively answer your questions.
Mm-hmm. There is a question from a property manager. Can he do the applications on behalf of the owners?
I do believe so. That's in the checklist that you will find on our website here. If you see our website, we have tenant and landlord checklists. I think you may have to provide some additional documentation just to show that you're authorized, like an agreement. But we can, if you don't get the answer by visiting there, please contact us and we'll make sure we can get that question answered for you.
A couple of questions, and one of them I'm going to answer and let you think about the other one. There's a question about what is the difference between a tenant applies or does not apply for the local program. Would that make a difference with anything else? And then let me get to the second question, which I'll answer first, which is if a tenant has moved out already, can the landlord go to small claims now, or do they have to wait till August 1st, 2021? My understanding is that the small claims courts are not accepting these types of collections until August 1st.
Mm-hmm. The first question, I don't think I quite understood.
So perhaps we can get clarification, but I wonder if the tenant applies or does not apply to the local program, does that affect their ability to apply to the state program?
These programs are going to be cross-checked, so no, they can apply if they go to the state portal. If they go to the state portal, they enter their information, and it turns out they are in the category that is better served by the other program. They're going to be directed to that program, but they're working together. So
I really appreciate all these questions, but I think we might have to wrap it up. And thank you again. If you have not received an answer, please email or call Project Sentinel or the city, and you will get some sort of response. So I really appreciate everything that you all have brought forward today. And thank you for participating. It's been a wonderful group. We hope you've learned something tonight. Go ahead.
No, go ahead.
Okay, I was going to say, as a reminder, when you log off, you'll get a link inviting you to give feedback on this program and on us as presenters. And we would ask that you really consider giving us feedback while your memory is fresh. It would mean a lot to our funders and to our organization. And if you don't do it right away, I believe you will get a gentle reminder. So if you have questions, contact us, and that's it for me. Thank you. Good night.